Probably the number one question we get regarding revocable living trusts is how do I transfer my assets into the name of the trust? So today we're going to talk about real estate and bank accounts. Two fairly easy things to do. The first one, real estate. Now, if you own your home by yourself right now, in other words, you're single, then your house is probably owned in your name. In other words, the title to your house is in your name. Let's say your name is Enrique Johnson. So your title on your house will have 123 Main Street, owned by Enrique Johnson. Now, if you're married, the title probably says something to the effect, if it was done correctly, something to the effect of Enrique and Sally Johnson, husband and wife, as joint tenants with right of survivorship. And you've heard me talk about in other videos how important having a property in joint tenancy with right of survivorship is. But today we're talking about how do we put that property into the name of your trust. And if you've gone to your estate planning attorney near you, this is usually a process that is done when you sign your revocable living trust documents. And it can be done with either a quitclaim deed or even a warranty deed, really depending on what our clients want. Either one will suffice to change the title of your property from Enrique and Sally Johnson to Enrique and Sally Johnson, trustees of the Enrique and Sally Johnson Revocable Living Trust. And what I just said there is the absolute key to transferring real estate into the name of your trust. Is you execute a deed, again, whether it's a quitclaim deed or a warranty deed, from your name, from Enrique and Sally Johnson, to the name of the trust, Enrique and Sally Johnson, trustees of the Enrique and Sally Johnson Revocable Living Trust. Depending on your jurisdiction, you will also probably be required to attach to the back of that deed what is called a certificate of trust or an affidavit of trust. And a certificate of trust or an affidavit of trust is simply a legal document that states that Enrique and Sally are the actual trustees of the Enrique and Sally Revocable Living Trust, and further, that they have the authority to do what is happening there today. In other words, they have the authority to hold real estate in the name of their trust. That's very, very important. And like I said, most jurisdictions will require, when you're transferring real estate into the name of your trust, to have the deed and behind it to have a certificate of trust, so it lets the world know and it creates a cleaner title or a clean title, and letting the world know that you are putting the property into the name of your trust. That is a very important aspect of transferring title from your name to the name of your trust. And again, it depends on what jurisdiction you are. So you need to check in your state with a local estate planning attorney near you to make sure you get this right. Because if you don't get that right, if you don't transfer your title correctly into the name of the trust, two things could possibly happen. The first, it might require a quiet title action. In other words, a friendly lawsuit to clear up the title to the property. And that's because there's some type of mistake or cloud on the title. So we need to do a quiet title action, which is kind of a mini lawsuit, and a judge has to make the decision whether or not title should be cleaned up. You don't want to go through the expense and the time of having to do this if you just do it correctly the first time. And the second thing that could go wrong, which probably is even worse than a quiet title, is that piece of real estate will have to actually go through the probate process. And you'll have to go through at least your heirs will have to go through the extreme expense and time of going through the probate process. And the whole reason you have a revocable living trust centered estate plan in the first place, well, is probably to avoid probate, right? And if you get the title to your real estate done wrong, you might have to go through the probate process to get that asset put into the name of the trust for distribution under the terms of your trust. So those are kind of the two big things that we see happen, or two things go wrong when people don't transfer title to their real estate correctly into the name of your trust. The next thing is bank accounts. People always wonder, how do I get my bank account where I have my checking and my savings into the name of their trust? This one requires a trip to your bank. You're probably going to go there anyway to deposit your monthly paycheck or to get new checks or to do something. So after you have signed your Revocable Living Trust Centered Estate Plan with your estate planning attorney, they are going to give you an affidavit of trust or a certificate certificate of trust. And again, just like I explained, those documents, it's really the same thing. That document, the certificate of trust, lets the world know that you have the authority to do what you're doing and that you are actually the trustee of your trust. So you take that certificate of trust down to your bank and you tell them, Mr. Banker or Mrs. Banker, can you please change the title of my checking account or my savings account from Enrique Johnson to Enrique Johnson, trustee of the Enrique Johnson Revocable Living Trust. And this usually just takes one trip to your bank, and most banks I have seen will usually let you keep the exact same account number. They just simply change your name to the name of the trust, and then you're done. Then when something happens to you, whether it's incapacitation or you ultimately pass away, your successor trustee can take over that bank account seamlessly without having to go through the probate process. Now, I've gone into more depth on transferring real estate into your trust and bank accounts to your trust in other videos, and I'll put links to those videos below.